Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
I'm Todd Marquardt. This is Talk Law Radio on 9:30 a.m. The Answer, and we're talking about wills, last will and testament, and somebody's calling in, so we'll see what their question is. But I was telling you the definition of a will. We talked about the definition of proper estate planning, and there's something else that you might want to know. The basic requirements of a will are it must identify the person who's making the will. So if you're making the will, you have to say that you're making a will, and who you are. You have to say, you can't just say, I leave everything to my dog Lexi, and not have your name anywhere there, because that would be very confusing. Has to name the testator. That's the legal word for the person who's writing the last will and testament. It must be written with testamentary intent. I'm going to go over this quite a bit because one of the challenges with a handwritten will is that people use their own words instead of legal words when they're writing it. And there's I'm going to go through several court cases where we discuss what is testamentary intent, and the reason these court cases exist is because some people messed up, and what they wrote was not necessarily considered to be a will, wasn't legally valid or enforceable. Next, the testator must have testamentary capacity. That means that they have to understand that they're making a will, among other things. They have to be over the age of 18, of sound mind, and the will must be executed with formalities. So we'll talk about the different formalities for handwritten wills and the different formalities for typed wills. Okay, let's go back. Proper definition of estate planning. If you're just tuning in, I want to control my property while I'm alive, take care of me and my loved ones if I become disabled, give what I have to who I want, the way I want, when I want. Furthermore, if I can, I want to save every tax dollar, professional fee, and court cost legally possible. Okay, we're going to be talking about wills. Why do we need a will? So that your wishes and your legacy are legally enforceable, so that your affairs are in order, to make administration of your estate easier and less expensive for your beneficiaries. So naming the executor is part of it. This is the person that's going to be wrapping up your affairs. And by the way, just a side note about executors, if you name somebody to be executor, what you're doing is you're really nominating them. The court still has to approve that person, and some people are not approved to serve as executor. And you might not know whether the person you've named has committed any felonies, but the court will find out because they do background checks on the executors. So you want to make sure that you know the people that you're naming. And if you don't know anybody, if you don't have friends or family that you trust, you can love somebody dearly and have no trust that they will do what they're going to say that they do. So then you might name a trust company, a bank, some professional like an attorney or a certified public accountant. A lot of those professionals have the skills to do what needs to be done, wrapping up your affairs, paying your bills, and distributing what's left to the beneficiaries. Okay, also in a will is where you make gifts to beneficiaries that take effect upon death. So I like to think of, who do you give gifts to at Christmas time? Who do you give birthday gifts to? Those might be the same people that you name in your will. Okay, So let's keep going. Also, part of an estate plan is more than just a will, because your body is part of your estate, and you want to take care of your estate while you're alive, including your body. And if you become disabled or incapacitated, then you need to give somebody permission to take care of you and your financial affairs and your medical and healthcare decisions. And you have to give written permission so that banks and financial institutions will honor the questions and instructions that are given by the person that's claiming to be your power of attorney agent. And also, something has to be it doesn't. For medical and healthcare, it's a little more complex. If you don't have a written medical power of attorney, there is a backup statute that says who is allowed to make decisions for you. And there's a list of categories of people that can do that. And doctors will pretty much listen to anybody on that list. It's just who gets there first and who can convince medical and healthcare professionals that they're acting the way that you would want them to do. But in any case, let me run down this list. In addition to the will, you also want to have a durable power of attorney. That's where you name someone you trust to make financial and legal decisions. A medical power of attorney, that's where you get to name someone you trust to make medical and healthcare decisions. I like to include a HIPAA authorization. HIPAA stands for Health Insurance Portability and Accountability Act. That's HIPAA. So that gives physicians and healthcare professionals authority to discuss your medical and healthcare information to people that you decide. So again, if you have questions about this stuff, you can call the radio station at 210-308-8867. You can email me right now if you want to at host@talklawradio.com. That's HOST @talklawradio.com. Or you can post a comment in the Facebook live feed. I'm just going to check my email right now and see if anybody emailed me. Not yet, but I'm still standing by. Okay, in addition to the will, the durable power of attorney, the medical power of attorney, the HIPAA authorization, I also suggest directive to physicians. That's where you get to that's where you get to decide in advance if you have a strong preference that you don't that you want to withhold or discontinue life support, or you want to be kept alive in the event that you're terminally or irreversibly ill or injured. So that's what's known as the living will. I don't like to call it that because in Texas, in the statute book, they call it directive to physicians. And that way it doesn't get confused with the last will or the living trust. So we have last will, living trust, or living will. So I don't like to use that terminology. I like to call it what it is, what the legislature calls it. Okay, so remember, we're talking about last wills today, and the question is to be or not to be. No, that's a joke. That's my joke. Ha. No, the question is typed or handwritten. Does it matter? Yes. One of the reasons why it matters is because testamentary intent. Now, I guess we have to make a further distinction because I'm assuming that if it's typed written, this is typed by an attorney. It's something that already has a presumption of legality. But if you type your own will in your own words, then you could probably make a lot of these same mistakes. It's just that when somebody handwrites a will, it's almost always using the wrong words, and the meaning of words matter. So that's how we communicate with each other, using speech or writing. And so that's why words matter. If you don't say what you mean or mean what you say, then you're going to cause confusion. Now, any married man will admit to that. So we're going to answer the question, typed or handwritten. Well, part of the concern is testamentary intent. And let me back up just a second. Why does this all matter? Why am I giving this information today? Because the assumption behind all of this is that you want to give your assets to someone upon your death. And do you want, how important is it for your affairs to be in order and for your gifts to be given to the people that you've chosen and to be given in the way that you intend? Is it very important for that to be correct? Is it somewhat important for that to be correct? Or is this something that doesn't really matter? That's what you have to ask yourself first, is how much effort and time and resources are you going to put into making sure that your will is correct? Okay, next. Testamentary intent. That's something that judges and courts have been interpreting since wills were probably ever understood. But I'm going to begin with 1955. That's when two members of the same family, Henson versus Henson, went to court. So the issue in this court case is whether the words used in a writing which began with supplementary to my last will, whether that was intended to modify or revoke the provisions of a typewritten document purporting to be a last will. So the law on this that the judge wrote in the opinion is, in part, an instrument is not a will unless it is executed with testamentary intent. The animus testandi, that's Latin, does not depend upon the maker's realization that he is making a will or upon his designation of the instrument as a will, but upon his intention to create a revocable disposition of his property to take effect after his death. It is essential, however, that the maker shall have intended to express his testamentary wishes in the particular instrument offered for probate. So, how do we make our intentions known? Well, you communicate. And one way to communicate is to say it, but everybody forgets what you said, or they remember only part of what you said. And so when you put it in writing, well, you can see clearly what it says, but the words that you use matter. And we'll talk more about why words matter, why the definition of words matters after this break. Then we'll continue talking about last wills. Should they be typed? Should they be handwritten? And who should type them? So stay tuned.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.